Please, Millets, am I audible and visible to my lord?
Yes, yes.
Millets, this is a section 37 appeal.
Yes.
Millets, the first primary ground. I'll just brief up your lordships on the grounds that have been urged, and thereafter I'll take your lordships through the documents. Millets, the first ground that has been urged is in relation to the failure of the 34 court to consider violations of my principles of natural justice.
No, no, just a minute. We are on the arbitration matter.
Yes, Millets. Yes, Millets.
Yes.
Absolutely.
So basically, the thing is this. You have now asked, the thing is that the arbitral award has directed you to pay compensation for 1257 trees.
That's correct.
You filed an appeal under section 34, that was rejected.
That's correct. Millets.
Then you asked for time, 1 month's extra time, additional time, that was allowed. Now you are challenging the award and the civil court order on the ground that some satellite image had shown that they could not have been an additional 1247 trees. Correct?
That's one of the grounds, Millets. The
Then-
primary grounds is something else.
What is the primary ground?
The primary grounds is that in this case particularly, Kala came up before the arbitral tribunal and made an admission saying that yes, I mistakenly did not consider 1247 trees. Now, by that admission of Kala, the arbitral tribunal bound me, that is a third party, by an admission of a first party. So a co-defendant's admission was treated against me.
Where is
and
that?
that's how-
Where is that
Yes.
in your pleadings? Where is that in your pleadings?
May I just show the award once, Millets?
You show me the pleadings, your pleadings. You cannot go beyond your pleadings.
Absolutely, Millets, absolutely. Millets, the petition starts at Millets will have my petition. Now, Millets will have ground F at page 41.
Page
41 of the petition, ground F.
yes.
Ground F onwards, Millets. The learned trial court erred in failing to consider that the impugned award is perverse and unjust in as much as it allows the claim of respondents in relation to trees without any assessment or evidence. It is of critical significance that Kala, in its reply dated 12th August 2025 to NHIDCL's communication dated 11th August 2025, candidly admitted that no photographic or videographic evidence was taken during the assessment in February 2022. The learned arbitrator thus directed the assessment of 1257 trees, beetle nut trees, without there being any independent documentary evidence to support the respondent's claim, rendering the arbitral award wholly perverse and unreasonable.
And anything else?
Then Malak's ground J, at 42, the last ground taken. Your Lordship
Yes.
has grounds because the learned trial court erred in failing to consider that the reasoning of the learned arbitrator directing Kala Kolasep to assess 1257 number of betel nut trees without any basis in law or facts is conjectural and renders the said part of arbitral award virtually unreasoned and liable to be interfered with by the honorable court.
So this is your case.
And then, my lords,
And
at
G
end,
and GH also. Satellite imagery of 2026 February.
that's correct. Ground L also very
Yes,
categorically
yes.
talks of promotion
Okay. L
deviation
also.
because the award partly allowing the claims of the respondent is contrary to law and conflict of public policy of India, permitting compensation to be assessed on the basis of intellectually and scientifically disapproved so and so, even when Kala itself admits that in absence of supporting documents in data daily actual so and so.
But this came only in February 26. When was the arbitral award announced?
Malaj, the arbitral award is dated 3rd June 2025.
3rd June 2025. And civil court order?
My lords, the impugned order that is before my lords is dated
3/11/25.
11/20. That's
3/11/25. When was the 3G award made?
my lords, that's there in your lordship's last order. Uh, your lordships have recorded all these dates. The 3G award, my lords, was passed on
3/12/24.
3/12/24. That's correct.
That's all.
That's it.
Now that is one part. Now
Yes,
you have. Now let us go to your writ petition.
that's correct.
Let us go straight to your application
Yes, ma'am.
for time. Come to page 46.
Page 46, my lords.
So page 46 is your application for time to pay.
That's correct. Yes, ma'am.
And this has been granted to you. Time has been granted to you.
Right.
Then how come you are challenging this? How can you challenge this? Just because it says that give me a report.
Miller's the fact of the matter is that today, before your lordship, it's not a private litigant.
Huh?
Miller's, I am not a private litigant before Miller's. Miller's, it's the
Correct,
exchequer.
correct. That is why you have got a higher responsibility to the court. You are not a private
Miller's,
litigant.
absolutely, Miller's are absolutely correct to that extent. Miller's
This is
also
you are
appeared
playing
with
you are playing around with the system.
the
You are making a joke of the system.
Miller's, the
This we're filing this
responsibility in
writ petition. Huh?
my respectful submission would be, Miller's, my responsibility would also lie to the exchequer. And if I find a discrepancy, then I am obligated to inform that to the honorable court as well.
Maybe, Mr. Counsel, but you cannot play around. You take time you take time for payment to be done. That time is given to you, and then thereafter you challenge the same.
Miller's,
Yes, you should be
very candidly, I
imposed with
find,
cost, heavy cost.
if I may very candidly also admit that part, Miller's, that I understand that the application was moved and it should not have been moved. I acknowledge and admit that part very candidly. However, Miller's, in my respectful submission, that court would cease to have jurisdiction once the judgment is passed.
No, no, that is
So
all right.
therefore,
Court should not have asked for report. That to that extent, all right, maybe. But then the thing is that extension of time has been given to you. How can you challenge the extension of time? You have asked for withdrawal of that. You have asked for withdrawal of the order.
we have asked for withdrawal of the order.
Huh?
We have asked for withdrawal
How
of
can
our
you ask?
original
How can you
application
ask for
as well.
withdrawal? You are out here. You in one forum you have asked for time, and in another forum you have asked for a withdrawal of that.
Well, it's
That's a
before the same
cancellation.
trial court.
Huh?
Before the same trial court, another application was moved. The moment the matter came to us, we intimated NHIDCL of those factors, and an application for withdrawal of the original CA was also moved.
Where is that?
In all,
Where is that?
well, that would be recorded in the order of the learned trial court. I'll just show that order to Miller.
You all are playing around basically. And another thing, can you bring out a new fact in the second appeal under order 37, section 37, which was never there a part of, which was never a part of the arbitrator's proceedings or before the section 34 application. Now you are coming. How can it be allowed? You pay cost. Yes, Mr.
My lord, I have very short submission. One, I'll just take you very straight. I have made already submission in the last court. I would like to take you to my counter affidavit to in that continuation of delay.
No, condemnation of delay will allow, we're dismissing it on merit.
Yes, that's my lord. The long and short of my submission is that new fact, satellite imaginary image cannot be brought. This is their only argument.
That's the only argument, correct.
Yes.
They cannot be brought at this
Yes,
stage
my lord,
after
that's
everything.
happened after finality of the award. Everything is final.
Correct. No, they can bring, say, if it was there prior to the award, it was there,
Yes.
and everything, or even during the arbitral proceedings,
Yes.
arbitration proceedings, they could have gone for it
Definitely.
for verification.
But
Not after section 34 application
My
has
lord,
been.
but in respect of that writ petition, I have very true good judgment where the Supreme Court emphatically, specifically ruled that Article 226 and 227 cannot be invoked in the proceedings of arbitration award because they.
No, that is there. Even I have reflected that Radheshyam has been followed recently.
Yeah, deep
Radheshyam
industry-
Chabinath has been followed
Deep Vendors-
recently.
Bhavin also I have two judgments.
No, there is a recent Justice Sandeep Mehta's
Yes,
judgment.
that's
is
those
there.
judgments.
That is recent. I know.
That,
No, that has followed Radheshyam only.
just because that they cannot stay order, then they intervene the forum.
No, they're just playing around. Where is your affidavit?
My affidavit.
Yes, in the application under section for Section 5 Limitation Act.
My lord, I have submitted. It will be there in the record.
Okay, basically, I am allowing the delay.
It's fine.
I am dismissing the appeal, and I am also dismissing the writ petition with cost of 50,000 rupees, which has been paid the State Legal Service Authority.
Millets, may I?
You can
may
go
I
in
only
appeal. You
request-
can go in appeal before the division bench.
Millets, may I only request that the cost may not be imposed?
No, cost will
Millets,
be imposed. In fact, I was
if
thinking
your
of a
lordship
higher
will see
amount.
the writ petition, if your lordship will see the writ petition does not impugn the impugned order that has been impugned in the 37 petition. Millets. It only impugns the further proceedings. And in fact, that's categorically disclosed also within the writ petition.
You cannot abuse the system, Mr. Counsel. You are not an ordinary litigant. You're the NHIDCL doing work everywhere.
My lords will just see the prayers of the writ petition at page 12. It does not even talk of the impugned order that is there
You
in
are
the 37.
asking for setting aside an order which has granted you your prayer for giving you time to make payment.
Therefore, Millets, in my respectful sir, I have not challenged that. So
You cannot
They are mutually
you cannot
exclusive.
even file a writ petition, in fact.
Mullad's writ petition would be permissible under 227. That's your lordship's
Maybe
supervising.
under 227 it is permissible, but your writ petition is under 226, 227. But
Yes,
then
Mulad.
227 what? On what ground are you challenging that? Not on, not.
Mullad's the fact that 34 court retained censy over a matter once it has passed the order. Mulad, there is a Supreme Court judgment to that effect. And that is what I had relied. Your lordship will see it in the last order of the writ petition court. The
What
court
has happened to
taken
the,
cognizance.
what has happened to the application before
Because of the
Supreme
stay order, they just keep it pending.
Court? Anyway, why have you kept it? You
My
call
lord,
for the report. That report business cannot be done.
My lord, actually in their enlargement of time, one of their prayer is that to place, they pray for to place the record of that satellite. Yes,
they said that?
Yes, it is there.
Let us see the order. If it is that, then, okay, let us see the order carefully.
My lord, page number 15 of my counter affidavit.
Page 50.
Parachi.
Just a minute. Yes?
This is their application, Parachi. The applicant is in the process of arranging the required funds and undertakes to comply with the payment direction with extended period of time as might be granted by this honorable court. In the event satellite imaginary and analytical report reveals any material variance in the factual position.
So basically they are trying to
Yes.
reopen a closed issue
Yes,
by way of this thing.
yes.
Cannot. Very cunning.
That's obliged, your lordship.
Anyway, maybe will maybe cost maybe lowered a little bit. That's all. Heard Mr. So and so and Mr. So and so. Then basically the condonation of delay is allowed. Yes, Mr. Jonathan, you are appearing for
I'm for Kala, Your Lordship.
Mr. Jonathan Lalit Wong
Yeah.
appears for respondent number 2.
Yes, Your
Kala,
Lordship.
for Kala. Okay.
I'm for responding number 1.
We'll come to my thing, room chamber will dispose it. We'll pass the order now.
Grateful, Mulad.